Article 1330. A contract where consent is given through mistake, violence, intimidation, undue influence, or fraud is voidable. So these are the vices of consent. 1 is mistake, 2 is violence, 3 is intimidation, 4 undue influence, and 5 is fraud. Characteristic of consent. It should be intelligent, it should be free, and it should be spontaneous. Concept of voidable contracts. Voidable or annullable contracts are existent, valid, and binding. Although they can be annulled because of want of capacity or vitiate consent of one of the parties, but before the annulment, they are effective and obligatory between parties. Hence, it is valid until it is set aside, and its validity may be assigned in an action for that purpose. They can be confirmed or ratified. Vices of consent in a compromise agreement approved by the court. There is no question that a contract where the consent is given through mistake, violence, intimidation, undue influence, or fraud is voidable. Under Article 1330 of the Civil Code, if the contract assumes the form of a compromise agreement between the parties in a civil case, then a judgment rendered on the basis such covenant in final, unappealable, and immediately executory. If one of the parties claims that his consent was obtained through fraud, mistake, or duress, he must file a motion with the trial court that approved the compromise agreement to reconsider the judgment and nullify or set aside said contract of any of the said grounds. Article 1331. In order that mistake may be invalidate consent, it should refer to the substance of the thing which is the object of the contract, or to those conditions which have principally moved one or both parties to enter into the contract. Mistake as to the identifier or qualification as one of the parties will vitiate consent only when such identifier or qualifications have been the principal cause of the contracts. A simple mistake of account shall give rise to its correction. We have two classifications of mistake or errors which vitiate consent, and these are the following. Vitiate, take away the legal force of the render, ineffective. 1 is mistake of fact. This is the mistake incurred by a party or both parties in the contract as the nature of the contract, object, substance of the thing, quality of the conditions of the thing, identify of qualification of the person, and quantity of the thing, where the quantity is the main reason for the contract. 2. Mistake of law. This is the mistake incurred by the party or both parties as to the legal effect of a certain transaction or act. Article 1332. When one of the parties is unable to read, or if the contract is in a language not understood by him and the mistake or fraud is alien, the person enforcing the contract must show that the terms thereof have been fully explained to the former. Discussion. Rationale behind the article. The Code Commission found it necessary to incorporate the article into the code because of its belief there is still a very large number of illiterates in the country, and documents are ordinarily drawn in English or Spanish. In the law of evidence, it is presumed that a person intends the ordinary construct his voluntary act, or a person makes ordinary care of his concerns. No contract shall arise unless its acceptance is commonly affected to the operator. The presumption does not apply in the following cases: when one of the contracting parties is unable to read, when the contract is written in a language not understood by the said party, if the contracting party is an illiterate, or even if the literate but he could not understand the language used in the contract which he signed, and later he alleged fraud and mistake in the execution thereof, there is a presumption created that there was fraud or mistake when he signed or gave his conformity to the contract. The burden of proof is shifted now to the parties who is enforcing the arrangement. He must prove that the document was fully explained to the party. Alleging fraud or mistake, failure to rebut the presumption will sustain the charge of fraud or mistake when there can be a presumption that there was fraud in the execution of the contract. If the contracting party is illiterate, or even if the literate, there is a presumption created that there was fraud or mistake when he signed and gave his conformity to the contract, if he could not understand the language using the contract which he signed, and later he
Article 1333. There is no mistake if the party alleging it knew the doubt, contingency, or risk affecting the object of the contract. Example, X acquired a house and lot from Z Property Holding. Historically, it is known to the public that the area is prone to flood during rainy days. When X transferred to their newly purchased house, the same house submerged in the flood. Thereafter, X demanded to cancel his purchase agreement with the Z Property Holding on the ground that his house was flooded. So, sa example po na to, malabo nang makancel yung contract kasi wala naman talagang mistake na naganap. Kasi bago pa i-purchase ni X yung property, alam niya na flood prone talaga yung area. Article 1334. Mutual error as to the legal effect of an agreement when the real purpose of the parties is frustrated may mediate consent. Example, A and B intended to enter into a contract of mortgage, but executed a document for a contract of sale, believing that both has same legal effects. So, sa example po na to, nagkaroon daw ng mutual error yung both parties. Yung mutual error nila ay nagre-refer sa legal effects. So, akala ni A and B, same lang yung legal effects ng deed of sale at deed of mortgage. The real purpose of the parties is frustrated kasi yung na-execute na contract ay ang deed of sale when in fact, yung nasa isip nilang dalawa ay mortgage. So, sa scenario na to, nagkakaroon po ng mediated consent at ang remedy dito ay annulment. Article 1335. There is violence when in order to wrest consent, serious or irresistible force is employed. There is intimidation when one of the contracting parties is compelled by a reasonable and well-grounded fear of an imminent and grave evil upon his person or property of his spouse, descendants to give his consent. Ang example po ng violence ay kapag ang isang tao ay binugbog para mapapirma siya ng contract. Sa intimidation naman, kapag nagkaroon ng pagbabanta sa isang tao or sa family niya para pumirma siya ng contract. So kapag nagkaroon ng intimidation or violence, yung contract ay magiging voidable, kung saan pwede itong ma-invalidate kapag nag-take na ng action yung injured party.
For Article 1336, violence or intimidation shall annul the obligation, although it may have been employed by a third person who didn't take part in the contract. So sabi dito na kahit pa yung nag-employ ng violence or intimidation, ay hindi makakontrata, and yet ito yung reason why you enter into that contract, the contract can be annulled, meaning voidable contract to. Kasi yung consent mo was vitiated. Like for example, Carl knows that a man is going to testify against his boss at his organized crime trial. So he confronts him and tells the man that he will hurt his family members and inflict damage if he takes the stand. So yun, si Carl, pinagbantaan niya yung lalaki na sasaktan niya yung pamilya para hindi siya pumunta sa trial ng boss niya. For Article 1337, there is undue influence. Merong requisites ang undue influence. Dapat may improper advantage of his power over the will of another. And because of that, nagkaroon ng deprivation sa reasonable freedom of choice. And there are also circumstances na kailangan i-consider in determining the undue influence. Dapat confidential, family, spiritual, and other relationship between the parties. Mental weakness, ignorant, or financial distress. So, take note lang na to vitiate consent, dapat ang influence ay undue. Kasi merong cases na nagkaroon lang ng persuasion, nagkaroon lang ng argument, hindi naman to prohibited by law. Hindi siya vitiated consent. What vitiates consent is undue influence. Like for example, the lawyer of Ben includes him to transfer his agricultural land so as to save him from imprisonment from a fraud case charged on him. Accordingly, Ben transfers his land. So, si Paul, tinake advantage niya yung pagiging law niya para makuha yung land ni Ben. And binigyan niya ng two options si Ben na kapag hindi niya binigay yung land, hindi siya, makukulong siya. Kapag binigay niya naman yung land, makakaligtas siya. Hindi siya makukulong. For Article 1338, there is fraud when, through insidious words or machination of one of the contracting parties, the other is induced to enter into a contract which without them he would not have agreed to. There are two kinds of fraud kasi. First is dolo causante or causal fraud, and the second one is dolo incidente or incidental fraud. Sa dolo causante or causal fraud, ito yung fraud na if walang fraud, hindi mag-enter sa contract yung other party. And sa incidental fraud naman, ito yung type ng fraud na kahit na walang fraud, if intention niya na pumasok sa kontrata, papasok siya. Ang effects lang talaga nito is obligadong magbayad ng damage yung nag-employ ng fraud. Requisites for dolo causante or causal fraud. 1. The fraud must be material and serious. Ito yung nag-vitiate ng consent na kung walang fraud, hindi siya mag-enter sa contract. The second one is the fraud must have been employed by only one party. Kasi if two parties yung nag-employ nun, legal na to, hindi na siya fraud, hindi na siya voidable contract. So dapat one party lang para sabi natin siyang voidable contract. 3 is deliberate intent to deceive. Yun nga yung sinasadya mong lokohin yung other party para mag-enter sa contract. And the last one is the other party must have relied on that untrue statement and must not be negligent. Like for example, A offered to sell a diamond necklace to B, claiming that the pendant of the necklace is a real diamond. A knows that it is not a real diamond but a fake one. If B buys necklace relying on the fact that the necklace pendant is fake, the sale may be annulled on the ground. Make the contract voidable. Yun, si A, pinenta niya sa KB yung necklace kahit na alam niya hindi yung tunay na diamond. Yung contract pwedeng ipawalang bisa kasi
Article 1339. Failure to disclose facts when there is a duty to reveal them, as when the parties are bound by confidential relations, constitutes fraud. Fraud by concealment. A neglect or failure to communicate that which a party to contract knows and ought to communicate constitutes concealment. In this case, concealment is equivalent to misinterpretation. Silence or concealment by itself does not constitute fraud. So the concealment contemplated in Article 1339 presupposes the purpose or design to hide facts which the other party ought to know. So the example for this is A and B are partners engaged into real estate business. So I sold a parcel of land to C for a higher amount without the knowledge of B. So the said parcel of land owned by the partnership. So in this given example, A is guilty for fraudulent concealment because he was under the duty to make disclosure of facts. Article 1340. The usual exaggeration in trade, when the other party had an opportunity to know the facts, are not in themselves fraudulent. So the discussion for this is the article refers to the usual exaggeration in trades, which are not fraudulent by themselves when the party has the opportunity to investigate and know the true facts. The exaggerations are also known as dealers to talk or traders talk, or dolus bonus, which constitute a tolerated fraud as long as the other party has the opportunity to check and know the facts. So, the example for this is expressions or advertisements, like the cigarette that will give you utmost smoking pleasure. Next, do you want your child to get high grades? Then buy him X fountain pen. So the law does not consider such exaggerations, even if known as false by the party making them, as amounting to the fraud that will affect the validity of a contract.
Article 1341. A mere expression of an opinion does not signify a fraud. Useless made by an expert and the other part has relied on the former's special knowledge. Example, Romeo on buying a watch was assured by the seller that it was a good watch and could run without rewinding for 1 week. In the opinion of the seller, this is a mere expression of opinion that is not fraudulent, but if the seller was a watch expert and only reason why Romeo brought the watch was the opinion of the seller, the contract is voidable on the ground of fraud. Article 1342. Misrepresentation by a third person does not vitiate consent unless such misrepresentation has created substantial mistake and the same is mutual. Example, Alex is the owner of the car worth 500,000 pesos. Alex sold it to Ben for 400,000 pesos because Carlo misrepresented to Alex that his car worth 400,000. Only Alex can annul the contract on the ground of misrepresentation commitment by Carlo, unless it was shown that Carlo conveyed with Ben misrepresentation value of the car.